The reason I think that it's mostly a red herring is that people have been using technology to help them create for as long as people have been creating. Okay, it could have been a paintbrush, whatever you use to paint on a cave wall, a hammer and
Right.
chisel to invent the
Yeah.
tools, and also conceptual tools, mathematics, language have been used to help create, whether it be writing, artwork, or again, inventing machines or new kinds of industrial processes. So those tools have gotten more and more powerful for sure. And the current state of AI would be the pinnacle so far of
Yeah.
those tools that assist in creativity. But they've been there all along. And at each stage, we've never said that means that the tool should be recognized by the law as an author in copyright law or as an inventor or a co-inventor in patent law. And I still think the answer is the same, no matter, even though the tools have gotten much, much more powerful.
You've
Yeah,
made a quote. An AI system does not have, this is really interesting to me. An AI system does not have desires, aspirations, or needs. It won't choose to invent rather than not to invent, work harder, or disclose its inventions to the public. Nor will it be demotivated if its name doesn't appear on a patents. Deeper, please.
yeah. So the reason why I think most people uh, think intuitively that the important question is whether an AI should be considered an inventor or an author is that when we use those kinds of terms colloquially outside of the law, we say, well, look, something like ChatGPT can create articles or written works that look like they're as good as at least an average human author. So why not consider it to be the equivalent of an author? That's a fair enough question, and we can debate about that. But
Yeah.
within intellectual property law, copyright and patent, there is a specific reason we grant copyright and patent rights to people. It's to motivate them to both create new works and to disclose those works to the public. Uh, it provides a financial incentive that you know if you're going to invent something and you obtain a patent on it, that patent will give you protection in the market, protection against competition in the marketplace. I mean,
And
the
that
way I'll
what's
put
fun.
it is intellectual property in the American conception, at least, is a very pragmatic, utilitarian type of system that seeks to maximize the amount of creative work that's created and disclosed to the public. It's not something
Hmm.
that's intended to reward creators or make them feel good about themselves or any of those things. And it's not intended to, yeah, it's not intended to answer, no, it's not intended to answer the philosophical question of whether someone is an inventor or an author, which we
Right.
could debate about separately. It's purely pragmatic and utilitarian to get more creative stuff created and put into the public sphere.